Good afternoon, everyone. Thank you for joining, especially on a long weekend. I'm just going to give everybody we have until 5 minutes before the official start time. So I'm just going to wait for others to join. If you have any questions that you want to send immediately, feel free to use the chat function, but I will attempt to answer questions as and when you have them. But again, I think maybe just give everybody a couple minutes before we actually get started. Thank you. All right, everybody, I think we are going to get started. I know it's a long weekend and I want to respect your time and not keep this going longer than absolutely necessary. For those of you that may be joining us for the first time, my name is Kripa Upadhyay. I am an immigration attorney with Buchalter PC. Buchalter is a national firm. We are currently at about 15 offices across the US. I and my team are based in the Seattle office. We also have an immigration attorney in Portland, Oregon. Joining me on this webinar is Eileen Duprat. She is an associate attorney in my team, also based in Seattle. My practice is exclusively corporate and investor-based immigration. And within that, I do quite a few EB1s, O1s, L1s, EB5s during the course of the year. Eileen handles a lot of the O1s and the non-immigrant visa applications. So we're going to try and tag team this as much as possible today. Again, like I said, I want to respect your time, but I also want to make sure that I am able to answer any questions that you have. So If you have any pressing questions, don't feel like you need to wait till the end of the presentation. Feel free to send them via the chat function. Eileen is going to be monitoring that throughout. As questions come in, she will let me know. We'll try and weave in any answers during the course of the presentation. I will also make sure to leave more than enough time for Q&A at the end. But, where we are now is basically a period where, unfortunately, the H-1B lottery has already ended. The results this year were, or well, the registration this year was not as bad as years past. We had a much better selection rate on average this year than in years past. That's obviously cold comfort to anybody that may not have been selected. And so for any of you that are here, maybe looking at the O1, we'll talk about what that means for you and what you need to do moving forward. The other issue that we are dealing with in the midst of everything else immigration related under this administration is the excruciatingly long time it is now taking for Department of Labor to complete a regular perm application, right? So that perm process, which some of you may or may not be familiar with, is multiple steps. The first step is to file what we call the prevailing wage determination, which is where we file the job description with Department of Labor. All they are meant to do is review that job description and get back to you with an average rate that has to be paid to the employee. And that average rate is based on the specifics of the job as described, but also the location and the metropolitan statistical data, right? So the specific city that you're going to be working at. When the perm process was instituted originally, we were told to expect, and it's again, perm's been going on for a while, but originally when instituted, intent of the whole program was that it was meant to streamline application process and to essentially ensure that no qualified US workers, right, US citizens or permanent residents were being unfairly disadvantaged in the process of bringing in or importing foreign labor, if you will. It was meant to take 90 days, start to finish, right? Where we are now is just that first part, just getting the prevailing wage, as I mentioned, which is step one, is at least a 6 to 8 month process. And by the time you finish the entire process, so your first step is filing the prevailing wage, then you move on to recruitment, to advertising, then you move on to labor certification. Once your labor is certified, then only can you file the I-140, right? So that process, getting to the point where you can file an I-140, is currently taking a year and a half. There is no premium processing to the perm labor certification process. So there is a massive increase in interest with respect to EB1 or O1. And then again, if you're born in India, understand that the perm, well, all of the immigrant visa categories in US immigration law are charged not to your country of citizenship, but to your country of birth. Non-immigrant visas are charged to your country of citizenship, right? So anybody that is born in India or China that is in the perm line, particularly India, anything less than an EB1. So if you're doing, even if you're doing an NIW, EB2 NIW, you're still going to be in an EB2 line, right? And so that EB2 line for India right now, India-born applicants right now, is something like 30 years long. And so if you're in a situation where you're facing a position where you may have been on H-1B now for 3 or 4 years, employer hasn't yet started your perm, you're likely going to hit your 6 year mark because it's taking a year and a half just for the perm process to finish. And so really, realistically speaking, right, your only option is to then either look at possibilities for an O1 or for an EB1A. You could go the NIW route, but we will talk about also trends that we're seeing with respect to significant spike in denials for EB2 NIW. And that's again because there's just been this mad dash of people filing for that, often not very well completed applications, maybe incomplete applications, or at least applications that are not structured as well and as strong as they could be, right? So with all that being said, that is why We decided to do this presentation. It just so happens to fall on a long weekend. So again, thank you to those of you that are joining us. Right. So the EB1 is analogous to the O1, right? These two sort of function in the same vein. The EB1 and the O1 are both self-sponsored. You do not need to have an employer petition for you unless you are filing for an EB1C. The EB1C is for a multinational executive or manager, which requires you to show that you were employed with a foreign entity outside of the US that is either a parent, subsidiary, or affiliate of the US entity, but you was employed full-time capacity with a foreign entity for at least the last 365 days before your petition to come into the US as a EB1C international executive or manager was filed. So other than the EB1C, your EB1As, your EB1Bs, your O1s, whether it's O1A or O1B, all of those can be self-sponsored. You do not need an employer. Filing for O1 is slightly different because the O1 does require a expert opinion to certify again that you coming into the United States and working in the area of expertise is not going to displace any US worker. So there is an expert opinion piece that is absolutely crucial to the O1. And there are designated organizations and entities that we are required to get that expert opinion from. Now, again, much of immigration law in the US was crafted in the 1950s. The last time we had significant change in immigration law was in 1980s. And so if you are filing for an O1, let's say in AI or in machine learning or blockchain or any of the buzzwords in tech right now, there isn't a dedicated entity that you can go to that can give you this expert opinion, right? And so in that case, your letters of support and your letters of your chosen expert panel, if you will, your supervisors, your clients, whoever is going to be writing your letters, those become extremely important. With respect to processing timelines, EB1 is preferred for applicants from countries with a backlog. Again, if you are somebody born in India, right, your EB2 petition, you're facing something like a 30-year backlog. The EB1 does, for India, does currently have a backlog as well, but it's probably 3 to 5 years wait in the EB1 category, as opposed to something like a 30-year wait in the EB2 category. Your O1 is a non-immigrant visa. This is not a path to green card, but it does allow you certain liberties that an H or an L do not. Primarily amongst those are that you can own and run your own business under an O1, and O1 is also not time-bound like the H or the L. Typically, an O1 is issued for a 5-year period, and then extensions are generally available for a year. So it's every year, 1-year increments, as long as you are employed with the same entity. If you move to a different employer, but you move in an O1 capacity, you can get extensions for up to 3 years. But there is no hard time limit like the 6-year on an H or a 5 or 7 year on an L, right? Okay. Contrary to popular belief, the EB1 is not reserved for the reborn Einsteins living amongst us, right? Now, I know that there is this sense of there's no way that I qualify for an EB1. I don't have patents. I don't have 100 citations. I have this conversation multiple times a week. So trust me when I say that patents are not required. Like hundreds of multiple citations are not required. Is that excellent to have? Does it help you build a much stronger application? Absolutely. If you don't have that, but you have the luxury of maybe waiting, should you do some serious profile building to try and get at least publications? Absolutely, right? That being said, EB1A and O1 are both going to be based pretty significantly on the quantity of your submission as opposed to, pardon me, on the quality of your submission as opposed to your quantity, right? And we'll talk about this a bit more in terms of the criteria and what that means. But there are 3 separate EB1A categories. Extraordinary ability is basically ability in the sciences, arts, education, business, or athletics. EB1B is specifically for researchers and professors. This does require you to be on tenure track or at least pursuing tenure track. And then multinational managers and executives, like I said, are for individuals that were employed outside of the US for at least 1 year. This, again, the EB1C is one where you do require employer sponsorship. But EB1A and EB1B too, if you are a researcher or professor, particularly at a university or college, that does require you, the university to support your petition or to petition for you. But the EB1A, which is where a majority of you will likely fall, is something that is self-petitioned. And you don't necessarily need an employer to file for you. The O1, again, is analogous to the EB1, and so your O1A is for individuals with extraordinary ability in the sciences, education, business, or athletics. O1B is specifically in the motion picture or television industry. O2s are individuals who are crucial to the performance or the ability to perform for an O1 artist or athlete. And O3 are essentially spouses and children, unmarried children under the age of 21 that will be accompanying either the O1 or the O2 visa holder, right? So in the O1 context, for example, Eileen and I have worked with multiple chefs, very accomplished chefs that we have been able to bring into the United States. And for those, we will bring in the executive chef or the head chef, and then also chef de cuisines for them to work in the kitchens. Right. Similarly, we've done O1s. My favorite is for a farrier. Um, and we were able to bring a farrier. I literally had to look up what a farrier was and what they do on that one. But we were able to bring in a world-renowned farrier who basically is an expert on equines and specifically horses and thoroughbreds. So the O1 allows for all sorts of things. There was a significant change in the last few months of the outgoing Biden administration, and they have now significantly changed the interpretation of an O1. And so it does allow for startups or startup founders to be eligible for O1. We have filed those as well. There are some specific issues there that I want to touch upon in later slides. All right, so benefits of the O1. There is no prevailing wage. There are no required minimum degrees. I mean, obviously, do I think it would be possible for somebody that, maybe doesn't have a bachelor's degree to immediately qualify for an O? I think it would be difficult, but again, this is very, very candidate specific. And so if you have somebody that did not earn a bachelor's degree, but has established a stellar business, whether that's in tech or in any other field, and they've won accolades, they are considered a leader in the industry. Is it possible for that person to be eligible for an O or for an EB1 for that matter? Absolutely. Right? These are very candidate specific. There is no one size fits all. The other thing with the O is if you are a individual that was admitted into the United States on a J1, particularly researcher or some similar, and you are subject to the 2-year home residency requirement, you can apply for an O1 via consular processing while you wait for your J1 waiver. Now, the J1 waiver has to go through the Department of State because the Department of State administers that program. And so there are some backlogs, if you will, with the Department of State, particularly under this administration. There are also, again, constantly changing policies with this administration. Those policies, anytime that they are viewed to impact national security, will impact processing of particular employment-based, in particular immigration benefits, right? So if you are from a country that the US at present considers to be not our best friend, that may impact the level of background research or administrative search that needs to happen on your particular petition. And so that's also causing backlogs for folks waiting for the J1 waiver to come through, which is why the O1 also becomes a good option for them. All right. So your minimum eligibility criteria, now there are a total of 10 criteria. These are similar for your O1, right? So your EB1 criteria and your O1 criteria mirror each other. It's just a question of how much do you have to put in, right? So the level of evidence that you have to submit for an O1 is much less, if you will, than an EB1. The one thing I do want to point out immediately is, in my opinion, having done this now for, I don't know, 17 years of being an immigration lawyer, if I don't make sense, that's probably why. I've been doing this way too long. My brains are just complete mush at this point. But the one thing that I very much would suggest is, here are your 10 criteria, right? If you're considering either an O1 or an EB1, do not, under any circumstances, try and hit all 10, right? Like I said, quality is better than quantity. That goes to individual evidence that you include per prong, but that also applies to the whole, right? Now, per regulation, it's very clear. Technically, you are meant to be eligible for EB1 or O1 with a minimum of 3 criteria. So any one of these 3 should be enough for you to qualify for EB1 or O1. In reality, that is absolutely not the case, right? And that's because immigration has decided that meeting a minimum of 3 criteria is not necessarily sufficient. And so typically for us, me particularly, I will not file an EB1 or an O1 unless and until I have 5, maybe 6 criteria that I am able to fully brief, fully support, and provide complete documentation and evidence for. Even when I do that, when I do the 5 or when I do the 7, USCIS, 9 times out of 10, will issue a request for evidence challenging 2 out of the 3, right? Or challenging 3 out of 5. Because for them, it's, let me just say, no, you don't qualify for this, that, and the other, so that you are now no longer regulatory eligible. So the risk with filing with just 3 is that you're going to get an RFE from USCIS saying 1 or 2 of your selected 3 has not been sufficiently shown. You will have an opportunity to respond, but it's likely not going to be granted because the service has said, and this is included in their decisions and in their RFEs, meeting the bare criteria, meeting the bare minimum is not always enough, right? So the importance of selecting the correct criteria, again, you are required to have 3. Again, as I said, my recommendation is that you not file an EB1 or an O1 unless you are able to show at minimum 4. My standard set is 5 or 6. I will not file an EB1 or an O1 without being able to meet at least 5 or 6. Again, these are subjective, right? These are specific to you and your story. And that is going to be a big part of these applications. The final merits is not an 11th prong, okay? The final merits is basically a complete assessment of who are you? What have you done? What do you plan to do? What evidence have you provided to an officer that is reviewing this that shows that you are at the top of your field, or that you are somebody who is more likely than not going to continue to lead this field, whatever that field is, right? You get to define your specialization. You get to define what it is that makes you the best there is out there. But you need to be able to select 4, 5, 6 out of these that give you the strongest possible shot at making that decision easy for the officer that's reviewing your application. Understand that immigration officers, even though they may have been doing this for a very long time, are not trained in the technical aspects of your application, right? So the problem that I find with some of my clients is when I have the initial consultation with them, I have to keep asking them to make it simple, right? Again, I've been doing this for 15 years. I don't understand all of the nuances of AI and blockchain and what training an AI model takes, right? How much work that takes, how much data that takes. Why is somebody who's primary function is to train an AI model that is going to be used in, I don't know, a level 4 autonomous vehicle. Why is that important? If you can't explain that to me in simple language, an immigration officer is not going to understand. Immigration officers are not necessarily scientists. They may or may not have any technical expertise or technical information even. Number two, they have a very limited time to go through these applications, right? They are completely backlogged. So they don't really have a lot of time to review these applications. When Eileen and I work on these, it takes us a good month to get all of this together, to get the documentation together, to get the supporting evidence together, to write the letters that we provide for your experts to sign. An immigration officer, on the other hand, looks at that entire month-long work that we've put in under 30 minutes. They are not going to review links. If you send them something saying, here's a link to a YouTube video showing me speaking, that's not being reviewed. That is not getting reviewed at all, right? And if that is one of your key criteria, you've already lost. You need to understand how immigration works. Again, explain who you are. What is it that you do? Why is that important? Do not rely on anecdotal evidence of what somebody did 3 months ago, let alone 3 years ago. It is very subjective. You could literally at this time, and it's not just this administration, this is true of the Biden administration as well. You could send two identical applications, 401 to immigration, and get completely different results. It depends on the officer that's reviewing your case, right? The one thing that everybody should do, and I don't see my clients doing this as often as I would like them to do, is take time to review what the critical infrastructure sectors are that have been designated by the US government. All right. So there are certain infrastructure areas that have been designated as critical for the United States. That includes healthcare, cybersecurity, data security, fintech, finance, certainly includes AI, broadly speaking, right? They don't have it broken down into AI versus blockchain versus whatever. It's just AI. Um, Again, when you're talking about more like manufacturing, technical, semiconductors, anything having to do with aerospace, defense, aerospace production, anything having to do with manufacturing, particularly under this administration. We have a full-on tariff, well, I will call it a tariff war, a full-on tariff war ongoing. And a great part of that, the biggest motivation for that, was to try and compel companies to increase manufacturing within the United States. So if what you are doing is helping that endeavor, make sure you read that link to understand what it is about your specific area that is critical, and that might give you some answers. Okay. Also, again, as I said, take the time to do this correctly. I understand there is a lot of fear and a lot of unknowns right now within immigration land. But take the time to do this correctly, because if for nothing else, for the fact that every application you file with USCIS has that question, which says, have you ever been denied this petition or similar petition before? The minute you say yes to that, you're already at a disadvantage, right? So try to do it once, try to do it correctly. That is also why you need to choose the right attorney to work with you. I have had clients who have worked with other firms, and I was told that the client was essentially the one putting together the application. We don't do that, right? Like I said, Eileen and I take about a month to work on these, but we will work with you. Again, 15, 17 years of doing this. I have not figured out a way to do this other than for this to be a partnership between the clients and the attorneys. That being said, this is a partnership. Let me be very clear about that. If you are going to come to us, and I will say this flat out, if you are going to come to me or to Eileen and say, I've already done my research, I want you to file this way, don't bother, because that's not me. That's not how I do it. If you're coming to us, again, this needs to be a partnership. If you want anything other than that, truly, I have not found a way to do this in any way other than for this to be a partnership. All right. Supporting your narrative. So, what are the things that work? Let's start with patents because that's always a big one. So, whether you are applying for EB1 or O1 doesn't matter. If you have patents, you have patents. That's something you absolutely should put as one of your main criteria. Patents typically would fall under original scientific business innovations, right? That's the broad line that it would typically fall under. So if you have patents, you're most of the time you're going to fall under this prong, evidence of your original scientific, scholarly, artistic, athletic, or business abilities, right? Now, if you do have patents, then the thing to understand is USCIS does make a distinction between patents that have been granted versus patents that have been pending or patent that is provisional approved, right? There is a distinction that immigration makes between those three. Also, patents as a purely academic exercise, i.e., you had this great invention, you applied for a patent, you received the patent, but it hasn't been used. There is no real use case scenario, is not something that immigration prefers to see. So if you have a patent, then the order, if you will, for immigration is, do you have a patent? Yes or no? Has that patent been granted? Yes or no? Is that patent being commercialized or has it been commercialized? Is it being used in a commercial sense? Is it being used in an academic or scientific sense? Either of those two count. But if you're saying I have patents, then be prepared to show all of that. If you're submitting an application saying I have 5 patents, 3 of which were granted, maybe 2 are pending, but of the 3 that were granted, none of them are currently being used, immigration's not going to look at that very nicely or give you the benefit of the doubt. Let me put it that way, right? So that criteria is probably going to get challenged. Awards and competitions. The competitions that you do not want to, well, not that you don't want to include, but it's not going to have any benefit, if you will, with immigration, is intra-college competitions or intra-university competitions, right? So for you to say, I was on the Dean's Medal or I was a presidential scholar at my university doesn't really mean much to USCIS because they're going to view that as restricted to a pre-screened or pre-approved pool of people. Now, are there things that you can do to distinguish yourself? Absolutely, right? Let's say you are a presidential scholar at the Harvards and MITs and Whartons of the world. Is that something you highlight? Absolutely, because you are already a part of an organization or an entity that has a very stringent criteria for admission, right? Again, my apologies, but I'm probably going to sound like a broken record because I'm going to keep saying this all the time. It is very candidate specific. There is no one size fits all to this at all. All right. Now, if you won an award or if you won a scholarship to attend a particular university, and again, it doesn't, I keep getting these questions. It does not have to be a Fulbright. It does not have to be a Rhodes Scholarship. If you have a Fulbright and a Rhodes, my hat's off to you. That is phenomenal, but that is not the required standard, right? If you won a competition or if you won a scholarship, again, who provided the scholarship? How many students or how many people were eligible to apply? How many applied? What was the process of selection for these applicants, right? Who is making these decisions? If it's a family-based scholarship and it was through some sort of a family foundation that your family owns or controls, unfortunately, that doesn't count for much with immigration. But that's, again, with awards, the more the competition, the more open it was to a more competitive field, the much better off you are for it, right? Memberships in organizations. This is another one that I think people get confused about. Membership in something like IEEE is great, but is an application saying, I am a member of IEEE going to help you with immigration? No. If you are a member of IEEE, they want to know, are you a senior member? Are you a fellow, right? Any organization that has multiple levels of membership, you want to be in the selected version of that membership. So they've got general members, you pay some sort of a fee, you get in. But to move from member to senior member, you have to have certain criteria. To move from senior member to fellow, you have to have certain criteria. They're looking for the senior members for O1s, they're looking for the fellows for EB1s. That's the distinction. Like I said, the criteria are the same. It's a question of which one requires more versus the other. Right. So now again, membership in organizations. We filed applications, I put it primarily on the EB1C front, where some of our clients have been members of various Forbes councils, and that really is self-explanatory, right? Like, I mean, if you made it to a Forbes council, I don't know what USCIS is going to find to challenge, but I give them, I say something like this, and then next week I'll get something saying, yes, so what if one of your clients has 5 patents? We don't mean any one of taking it seriously. Um, Advisory roles. If you have served as an advisor on any, now again, coming back to any of you that may be in the tech industry, if you've served as an advisor or are serving as an advisor for any company that has launched or is launching a product or a service that has been critically acclaimed, right? That is absolutely something you want to focus on. Now, if that advisory role was specific to your technical expertise or your financial expertise or whatever your area of expertise is, absolutely hone in on that, focus on that, get letters of support to show that. Articles or publications about you and your work product, I'm going to come back to because this is my least favorite of the EB1 cottage industry that has now sprung up in the United States. Judging and mentoring. Judging is basically, have you worked as a judge of the work of others? What does that mean? For those of you that may have your master's or your PhDs, that means working as a reviewer for publications before they get published in peer-reviewed journals. That's your easiest one. That they're always looking for reviewers. That's probably one of the quickest ones that you can get. Mentoring tends to be a little more difficult, but for those of you that may be, again, in the tech industry, you've worked at a startup, maybe you worked at a startup that had a successful exit and now you're at another one. And so if you are mentoring young entrepreneurs, whether that is through something like a Y Combinator or even a TIE, for those of you that know what the Indus entrepreneurs are, TIE has a startup pitch that the competition that they do. I think it's with every TIE chapter. And so if you are working as a judge or a mentor in one of those competitions, that works too. Publications of articles, again, always helpful, but just having a slew of articles published or multiple publications, but no corresponding citations is not terribly helpful, right? So you are not required to have publications. You are not required to have multiple citations. For O1s, having articles published is enough. You don't need the citations. For EB1s, having articles published only is not enough. You need the citations, right? So again, the difference between an O1 and an EB1 is the level of evidence that you need to provide in support of either. Same thing with the leading or critical role. Your letters of support have to be specific to your role. Now, in an EB1 context, they have to show that your role was critical to some event or achievement or product launch or product development, whatever it may be for the company. You were critical to that effort, right? O1, you played a leading role. So I'll often get questions from um, project managers, PMs. I'm just a PM. Do I qualify? If you're a PM and you're looking for an O1, just the fact that you were a PM of a project, yes, that's enough. Is that necessarily enough as a leading role? Probably not, unless you can show that as a PM, you did XYZ that was critical to the outcome of that project. Okay. High income earners, again, I've literally put it in there, very difficult to get USCIS to agree because they will never agree. They will throw up 1,000 flags on the high income earner, right? So doesn't mean that you don't include it. You absolutely should. I would just be careful. Like if you're saying you have 4 criteria, make this one your fifth, right? If you're saying you have 3 criteria, absolutely do not use this. It's really as simple as that. But bonus, stock grants, evidence of salary, all of that works well. At least for us, we tend to use different for Eileen and I, we tend to use different data points when we include this, right? So like pay.com, salary.com, like one of those, if you can find similar rules on LinkedIn and see what the salary range is versus what you are getting, all of that counts as anecdotal data. But this is still going to be difficult for immigration to get past immigration, right? Moving to the publicity thing, like I said, I have a problem with this. I just don't agree with the entire cottage industry of I'm an O1 coach, let me sell you a package for 600 and let me get you published in 3 different places. That seems to be all the rage right now. You want to be and you need to be very careful about doing these paid publicity things, right? Immigration is not stupid, personal opinion aside, they understand what they're doing. So publications in, let's say, for example, you have a published piece about you in some magazine in the Silicon Valley, but the service knows that that magazine typically is a PR run effort, right? Meaning that if you have a good public relations person, you'll get a cover story published about you, or you'll get an interior profile printed about you. Immigration knows that. They understand that that's what it is. Also, articles that you have paid for, typically these packages that are being shopped, that's for a 6-month period, right? And the problem with that is the regulation requires that you be able to demonstrate sustained national and international claim. 6 months is not sustainment, right? So I would much rather that you spend maybe a year to 2 years working on this thing and getting a slow trickle of publicity out there, putting yourself out there, writing articles, writing blogs, whatever you need to do, then this massive all-out effort for 6 months, and then nothing after that, because then you're not meeting, number one, the sustained prong. Number two, articles that you pay for that are not organic are very easily set apart from organic articles, right? Just because the timing of it is going to be different, the placement of it is going to be different. So is that saying absolutely do not engage in one of these, paid publicity packages that are all over the place right now? No, I'm just saying be very careful. The other thing, the other reason why you want to be careful is also because all forms of immigration benefit whatever you file for anytime you file for them. There is a very strong prohibition against engaging in fraud or misrepresentation of the fact, right? And so there are awards that you can purchase, for example. I would absolutely steer clear of those. Like I did a consultation once for somebody who actually, I will leave unnamed, but this person runs a very successful cottage industry of, I am an EB1 coach, let me show you the way kind of thing. And he called me on behalf of a person that he was working with who had multiple awards from South Africa and Nigeria. And what was interesting was that this individual had never ever spent time in South Africa or Nigeria, yet had all of these publications about him in articles and journals in South Africa and Nigeria. Turned out every single one of those awards, very nice, beautiful glass and metal trophies, were essentially the buy an award genre, right? I would caution you against doing something like that, because the very last thing that you want is for immigration to come back and charge you with misrepresentation or fraud. A fraud finding in immigration matters is a lifetime bar against any other visa application, including a visitor's visa or a tourist visa. Especially under this administration, you do not want to take unnecessary risks, right? So if you find that you need the help, you want that publicity, you're on a time crunch, absolutely. If that's, understand the risk and go forward, but be careful about how you do it. But understand that if you're, all of a sudden going to have this blitz of 6-month advertising and then nothing prior to or after that, immigration is going to catch on to that pretty quickly. Okay. All right. I want to take some time and see if we have any questions. Eileen,
There's a
you want to
question
jump in?
from Fuzzy. They have a question about how to show their contribution when they're a part of a project and it was submitted as a name of the company and his name is not particularly published or released in the article.
Okay. So for something like that, and that's actually pretty common, for something like that, I think the best thing to do is to speak to whoever the lead was on that project. So your supervisor, manager, or whoever the lead was on that project, and get them to write a letter of support for you about, again, your unique or critical work or your unique or critical contributions to that, um, that product, that initiative that your company did. Now, if your title is, let's say, project manager, and on LinkedIn you're saying, I'm the project manager for, I don't know, Meta VR goggles or what have you, then can you include articles about that specific product? Absolutely, but you should also try to have a letter of support from a supervisor or a manager speaking specifically to that. Okay? Oof, okay, the chat questions are coming in fast and furious. All right. Eileen, do you have most of these?
Yeah.
Okay. So again, sorry, just going back to this one here about 4G, 5G cellular, I'll tell you right now, telecommunications cellular is one of the critical infrastructure industries. So that's absolutely something you should look into, and then frame it based on your critical role and your work in that realm. Okay. We will go over contact information in just a minute. All right, someone gets an O1. Why would they apply for EB1? The O1 is typically sometimes a really good starter to the O1. So I mean, the O1 is a very good starter to the EB1. The O1 is a non-immigrant visa. The O1 does not get you a green card. And so if you have an O1, USCIS has a much more difficult time declining or denying your EB1 because they've already essentially assessed you as being somebody who is in the top 5 to, let's say, 10, yeah, 5 to 10% of your field, right? Again, the O1 and the EB1 are similar. Your O1 is essentially saying you're in the top, let's say, 15% of your industry or of your area of expertise. Your EB1 is saying you're in the top 3 to 5%, right? So if you've already been approved for an O1, ideally, typically for us, the way that we plan these, the way that I plan these for my clients is if I'm helping you get an O1 in 2025, I will not file the EB1 until, let's say, 2027, so that we have a good 1 to 2 years time to show all the achievements, accomplishments, work that you have done inside the US that has been to the benefit of your industry vertical within the United States or abroad. And then again, to the extent that you can, I did X, this is the commercialization for this project or this product. This brought in Y money. This has helped the US enhance our standing as a leader in science, as a leader in technology, what have you. That then helps make the EB1 a much more seamless application, if you will. Okay. All right. Now, I want to spend some time talking about specific client cases that we've worked on so that you have, I guess, an idea of what, the crazy cauldron at my office of which is brew to try to get these applications through USCIS. But let's say you are a lead engineer building a fully autonomous vehicle. This is actually a case that we had, or that I filed with USCIS. The applicant in this case had 5 patents, all of which were fully commercialized for this autonomous vehicle. The vehicle in question is currently, or probably already come out of it, being road tested in the US and in Europe. Okay. Why is this important? You have to look at it from an AI, tech, engineering, pedestrian security, national security issue. Okay. What does building an autonomous vehicle have to do with national security? An autonomous vehicle, to some extent, especially once they reach the level 5 and level 6, right? You're basically putting that in self-drive mode. Now, when you're putting it in self-drive mode, the car needs to understand the difference between a human versus a trash can, right? If there's a curve in the road ahead, how does it curve? How does your car essentially navigate that? A lot of that is basically feeding data into a model, right? And then you feed the data, you test it, you make some changes, tweaks, you feed the data, you test it, you make some tweaks until you finally are able to integrate it. That goes to safety, both for the driver, traffic safety for pedestrians, traffic safety for anybody else that's on the streets. Ensuring the lives of people on our roads in the US, regardless of their citizenship, is a national security issue because you obviously don't want random cars out there mowing down people because the AI didn't work, right? So you have to think of it in that granular a fashion. Now, let's say you're a supply chain manager, right? Because again, these are titles that I most often get questions about is I don't think I qualify. If you're a supply chain manager for a drug that was produced and sold primarily for diabetes, but it is now being used for obesity, how does that help you for purposes of an O1 or an EB1? Supply chain manager, and for those of you that work at Amazon, Jeff Bezos is, I think, credited with finding the best solution for the last mile, right? I think he was like hyper focused on the last mile. But that's basically what you're doing, right? A supply chain manager is responsible essentially for ensuring that any product essentially reaches the end user. Okay. Diabetes is essentially a life-saving drug. So is obesity. Health data in the United States points to obesity being a major fatality factor, right? A lot of death associated with obesity and related health outcomes. And so if you're saying you are a supply chain manager, you didn't develop the drug, you didn't perform any earth-shattering inventions as far as the drug is concerned, but you're a supply chain manager and you're responsible for making sure that these life-saving drugs make it to Joe Schmo on the street that needs to use it in order to survive, right? Is that a national security interest? Absolutely, because again, it's going to health and safety of US citizens, right? And health and safety of US citizens in terms of the larger community. So lower lower instances of death based on diabetes or obesity, better health outcomes, longevity for people in the United States, um, less use of limited resources, as in hospitals, surgery, what have yous, less use potentially in terms of government-supported healthcare, Medicaid, Medicare, all of that, right? All of that comes in. Now you're probably looking at me going, what on earth are you talking about? That's not at all what I do. What is the end outcome of your work? You have to be able to build that chain, right? Um, okay, so hopefully that was helpful. Um, all right, options for students, because I get a lot of these questions, particularly right now with the H-1B lottery just having finished. There is no prohibition at all in the regulations, or at least in immigration law, which says an F1 student or somebody on an OPT or a CPT cannot then apply for an EB1A or for an O1. There's nothing that says that. It can be done. It has been done. I have done it. I had a student that was on an F1 OPT, but he is one of these brilliant people. And he had some patents, engineer, had some patents to his name that were being used again by his company. So to the person that asked, right, like I work at a company, what does that mean for me? That's why I'm telling you, you work with your supervisors and your superiors and your managers to get this done. In his case, what we were able to do was work with his managers to essentially get very detailed letters about his critical role in the creation, design, deployment, engineering of specific products and services. Now, you have to remember again, this person was on an OPT, right, on an F1, but he really was the lead engineer in a sense for a lot of the products that were being put out by this company. And so again, there is no prohibition against an F1 student if you are able to do this going from an F1 to an EB1A or an O1. The thing you have to be careful about is not overextending yourself over that very fine line of any work you may have done, especially if you were on an F1. If you are on an F1 outside of OPT and CPT, you do not have the authorization to work. Right now, you can volunteer. So let's say while you were on an F1, you were working on a startup idea, and all of a sudden that idea took off, and you ended up having to do some work in order to expand on your business. And that business or that product or that service that went viral is now the basis of your OP, your EB1 or your O1 application. I would say be careful only because whilst you are on an F1, you are not authorized to work or do anything that constitutes work, right? That counts as work. And so the last thing you want is to file an O1 or an EB1 application and then have the government come after you and say, thank you very much for sending us this. We now have evidence that you violated status. Not only are we going to deny this application, we're also going to put you in removal proceedings, right? So can you do this? Can you go from an F1 to an O1 or an EB1? Absolutely. Several things you can do. Again, practicum internships, research assistantships, fellowships, particularly if you are in the technical field, in the science field, if you're working in a lab, if you're working on something that is already in process and you come in, I don't care, the last 6 months, but that thing ends up getting a patent. As long as you are named on that as a named inventor or a co-inventor, that's fine. That works. Okay. Um, but yeah, that's absolutely something you can do. Right. Now, red flags, like I said, paid publication packages. This one I'm just always very, very, very careful about. Again, awards from countries you have never set foot in, you have never worked in, you have no relationship with that country. Ghostwriting AI-generated publications. There are a lot of these right now on Medium, for example. Again, an organically written article is very easily distinguishable from an AI-generated article. All right, so just be very careful about this. Judging Globee and Stevie awards if you are a C-level executive. Globee and Stevie, in and of themselves, are not bad. I will tell you that immigration is seeing just an absolute mountain of applications right now. NIWs, O1s, EB1s, every single one which says, I acted as a judge or a mentor of others because I was a judge for Globee or Stevie. And if you look at, I think it's the Globee, if you look at the number of judges on Globee the last year, I think it was close to like 300 people. Okay. So that takes away from the exclusivity, if you will, right? Which is important for an EB1. It's very important for EB1. Can you do Globee and Stevie for O1s? Absolutely. But if you're saying I was a member of a judging panel, how many judges were there? 300. That's going to take away from purposes of your EB1, right? So just be careful about how you're doing this. Again, we've already talked about the profile building. Most of these paid publication packages are 6-month long terms, right? That does not mean the requirement for sustained national and international acclaim. So just be careful there. I think the organic, if you have, 3 criteria and you need another three, and one of the things that you're missing in your other three is publications. Should you do a paid publication package? Sure, because you have 3 other things, right? But if you have nothing and all of a sudden you go out and you're all over the place for the next 6 months and then there's nothing after that, that's an issue. So reality of current adjudication, and this is, I understand we're in, 2025, but immigration data comes out very, very slowly. So EB1 approvals have dropped pretty significantly, which shows that there is a much more stringent adjudication regimen here. Denial rate has increased. Pending cases rose to 16.03%. What does that pending case mean? It basically means a lot more requests for evidence or a notice of intent to deny, which is what the NOID is, right? The NOID is the notice of intent to deny. O1 generally much nicer metrics, much friendlier in terms of, closer to 80. I think we're down to 80% actually on that one now, down to about 80%. But USCIS is also challenging O1s a lot more. We are seeing a lot more RFEs, that require you to meet EB1 standards in an O1 application, and that is not the requirement, right? There has been an upward spike in RFEs and denials after January 2025, which, no surprises, coincides with this current Trump administration. But we are seeing a higher spike, but O1 still has much nicer, much more beneficial outcomes, if you will, than the EB1, right? The things that I want to, I guess, leave you with is when you're choosing an immigration attorney, I know a lot of clients will call and say, well, such and such is giving me a 50% money back guarantee if the application is not filed. That's not something that we do. That's also not something that I recommend for clients to engage in, because if there is an attorney that is saying we'll give you a 50% return on an application if it does not get approved, then that means one of two things, right? They're either working off of templates for similar cases that they did in the past, or they just have some massive volume where they're able to essentially regurgitate significant portions of the brief for subsequent cases. Again, every application, O1, NIW, EB1, has to be very specifically tailored to you, the individual. Who are you? What have you done? Why is your work important? Why are you the best person to lead this forward, right? That doesn't come necessarily with a firm that maybe has 75 other EB1s that they're dealing with that are on a similar timeline. So just be careful about who you're working with. Again, this needs to be very much a partnership between you and your attorney. The one thing that I did want to go to, for those of you that are joining us this afternoon that may be thinking about startups and applying for O1 as a startup founder. So as I said, that was late into the Biden administration. I think that actually came out like October and November. So literally the last few months of the Biden administration, we got the O1 rule, or what we call the O1 rule is really just restating what immigration was already doing. But what the O1 now allows specifically for startup founders is one, you can be the majority owner of your own startup and file for O1 and qualify. Number two, you can use funds that you have raised, right? So VC grants, venture capital grants, seed funding is still a little difficult, but if you are a startup and you have raised VC money, you can absolutely use that as an award. Be ready for pushback from immigration. And again, this is interesting because I'm currently in the midst of an O1 for a tech founder, startup founder, who is really phenomenal. One of the first products of its kind to market. And I have an RFE from USCIS saying, well, you can't count the award, you can't count the VC grant as an award because in this particular immigration officer's mind, an award, and this is literally in the RFE, an award is something that you receive at an event where there is a podium. Okay, so again, the reason I'm raising this is because this is what you're going to be dealing with immigration. The regulations say an award for purposes of a startup can be funds raised from a venture capital grant, right? What immigration officer is telling me is no, this doesn't mean the same thing. When we say award, we mean, like you walk up on a stage and somebody gives you a plaque and maybe a garland, and that didn't happen. So this is not an award. So yeah, you're going to be dealing with that. Also, the other thing with awards, with VC funds and startups, be careful for those of you that may be thinking of doing this. If you are thinking of going forward, showing any seed funding or pre-seed funding, that is going to be discounted by USCIS, because if you're one of your criteria, right, again, going back to, where is my list of 10? Okay, if we're going back to this, if one of your chosen criteria is evidence of performance of a leading or critical role in a distinguished organization, right? If
Mm.
this is the one that you're going for, and you're showing that you received seed funding or pre-seed funding, what immigration seems to be using now is Well, you're obviously not a distinguished organization because you're very early in your journey. Otherwise, why would you be receiving seed or pre-seed funding, right? So there has to be internal consistency between each of these points that you select, which again, and I'm going to end with this is absolutely crucial to your application. The importance of selecting the 4 or 5 criteria have to match with your narrative. Who are you? What have you done? How have you contributed, you personally contributed to this specific area of expertise? Because those 2 prongs is basically what the final merits is based on, right? Now, the final merits is less used in your O1. It really comes in more as in the conclusion statement for your O1, but it's absolutely essential. So again, be very careful about how you are selecting your criteria. Like I said, I'm going to be a broken record. There is a reason why this is a partnership between the attorney and the applicant. It's going to take time to select these 4 or 5 based on what you have versus what you may have in 6 months, right? If there's some level of internal inconsistency, but that can be dealt with in the next 5 or 6 months, you are much better off waiting that 5 or 6 months so that you have a better outcome here. Okay. But that is basically what I want to leave you with. I will, um, again, feel free to just unmute yourselves and ask questions if you want. We are at the hour mark, and so I also want to be respectful of your time. Let me get to this one. Support engineer role, where the engineer is responsible for Gen AI under critical role. But I'm going to say potentially to this. I'm going to say potentially yes to this because is Gen AI one of the critical infrastructures? Yes. Does that necessarily mean saying I'm critical infrastructure employee is all you need to do? No. So it would really be more about what specific role are you playing in terms of Gen AI for AWS, right? Why is that important, either to AWS or to its customers? What is your specific role? So again, it comes down to who you are, what you're doing. So I'm going to say yes to that, but definitely need more information. All right. So in case you need to get in touch with us, again, the office is Buckalter. My phone number, my direct number is 206-225-1167. Eileen, you want to share yours?
Yep, sure. I also gave them your direct email, so they can contact you. A lot of people wanted to see if you can review their credentials to see if they qualify for EB1A or even O1. So,
Yeah, so we do credential evaluations, or I guess, evaluations for O1 or EB1. That is the process for that is basically I ask you to send us the resume so that we can review ahead of time, and then we set up a consult. The consult is charged just because I'm doing so much of this.
right.
If you hire us to go ahead and file, then we will credit the cost of the consult to the case. So you're not having to pay for 10,000 different things. Um, no, hang on. That's the wrong number. It's two zero
Is it?
six 225
Oh,
1167.
sorry, 225. My fat fingers.
All right. But you have my email address. You
Yeah, that
have
was shared.
Eileen's email address.
225
And
1167. There we go.
but if you go to Buckalter, you'll also find our contact information there. So feel free to contact us. More than happy to try and help you through the next steps. But again, it is into the hour and the sun is shining in Seattle, which very rarely happens. So please enjoy your Memorial Day weekend. Thank you all for joining us. That will be it. Bye.